civil and criminal trial procedure. So, introduction, we are talking about section 408 and 410. What is that? It talks about the constitution of NCLT and NCLAT. Okay. Both are powers of the civil code. Are you aware about that? First you tell me that. Not exactly which law should be followed. Okay. It is more in terms of what does Companies Act contain, what does the Code of Criminal Procedure contain, and how it interplays with each other. Some places in Companies Act is talking about the CRPC. And if it's a criminal offence, it will go into CRPC. So how does CRPC work? That also you will be having to understand. Criminal Procedure Code, you will have not done much. You know that the NCLT and NCLAT have the powers of a civil code, right? So, jurisdiction is specified. How is the jurisdiction for them specified? You are aware about this? In case of an order against a company, based on where the registered office of the company is situated. In case of an order against any other person, where the person voluntarily resides or carries on business or personally works for gain. So depending on that, the jurisdiction of the NCLT is specified or NCLAT is specified. This part is clear, right? What is Code of Criminal Procedure? It's a procedural law which came into force from 1st April 1974. It applies to every law, every offence punishable under IPC, Indian Penal Code, or any other special or local law. It applies for all offences which are punishable under special or local law where it is a criminal offence. Okay. So for offences under Companies Act 2013 or Companies Act 1956, the substantive law is that act itself. There's two types, no? Substantive law and procedural law. Substantive law tells you what should be done, what cannot be done. Okay. What is prohibited, what is permitted with some conditions maybe. That is substantive law. What is procedural law? Procedural law tells you how to do what you are supposed to do. So here in Companies Act, what they are saying is, this is a substantive law. That is, it tells you what you can do, what you cannot do. Alright. The trial procedure for offences under any law in India will be in accordance with the provisions of CRPC. That is, whenever there is a criminal offence, the trial procedure will be as per the provisions of Criminal Procedure Code. Unless that respective law tells you how it has to be done. So a different procedure if it is given, then you do have to follow that procedure. Otherwise, you will follow the Criminal Procedure Code. Am I clear to here? Okay. So substantive law creates and defines offences, prescribes penalties for commissions of offences. Criminal Procedure Code contains a complete procedural code for trial of the offences. That's how the differentiation is. So how does it work? It creates a machinery, no problem. do it. Okay. Of course, I'm going to put pressure on you on cases also at the same time, but still you will have to do that. It is not very big. Creates a machinery for detection of crime. So we are talking about CRPC. Apprehension of suspected criminals. Collection of evidence. Determination of the guilt or innocence. And then imposing suitable punishment. So for each of this, it gives you a procedure. That is what Criminal Procedure Code is. It is a mechanism for investigation and trial of offences. How? Effective administrative and judicial process. So that there is a speedy and less costly trial. Okay. So, as per section 4 of CRPC, before I go into object of trial, I just want to cover 2-3 things. As per section 4 of CRPC, offences under any other law other than IPC will be investigated, inquired into, tried as per the provisions of CRPC, unless that enactment specifically tells you the manner in which it has to be done. Section 5 says, in the absence of a specific provision to the contrary, nothing contained in the CRPC will affect any special or local law which is already in force. So that means if a special act applies, that is what will be taking precedence over the CRPC. Okay? If there is nothing specifically contained in a special act or under any other law, then the procedure under CRPC must be followed. Am I clear till here? Yes? I'm going deliberately very slow because this is foundation for many things that we are going to speak about in the chapter 7. Okay. What is the object of a trial? Somebody has been accused of doing something wrong, right? The object of the trial is to find out the truth and determine the innocence or the guilt of the accused. Obvious? Article 21 of the Constitution of India says, no person shall be deprived of his life or personal liberty except according to procedure established by law. Many of the offences in Companies Act is inviting strict liability for the company, also for the officers in default, without any proof of guilty frame of mind. It's very critical to understand. Okay. There is therefore normally what is the principle under law? That you are innocent until proved guilty, no? But here accused, there is no role for that principle that the accused is innocent until proved guilty by the prosecution. It should be. Are you clear? So in exercise of the powers under Companies Act 463, it is possible for the court to try the offence to reduce the fine to an amount which is less than the minimum fine. But basically that innocent until proved guilty may not happen. Are you clear to here? Also, another thing that they are talking about is mens rea. That is, what is the meaning of mens rea? Are you aware? Correct. Okay. So, one important thing is, typically court has to see whether somebody is had that intention. Correct. What is the intention of a person who is doing the fraud? Is it willful or is it innocent? So, except with respect to offences involving fraud or mens rea or requiring proof of knowledge of involvement, the general criminal law system of deeming that the accused is innocent until prosecution proves a guilt does not apply. The intention of the parties committing such violation is wholly irrelevant. Very, very critical point it is. Are you clear? So if the director or officer deserves relief, he has to apply specifically to the court and court can reduce the penalty. That is what it is saying. Okay. Now we will come to criminal proceeding vis-a-vis civil proceeding. What is a civil proceeding and what is a criminal proceeding? Civil proceeding is concerned with a civil right with reference to common law or law created by any statute. I am assuming you know what is common law and law created by statute. It is taken to a logical conclusion. What is criminal proceeding? A criminal proceeding includes all proceedings which are instituted under ordinary criminal law of land. It is not confined to only proceedings under CRPC or IPC. It is any offence under any law which is a criminal case. Okay. So in all those cases, the CRPC will be followed. The method of trial of offence will be followed. They have written lot of things in between about what happened in different court cases. Okay, that you have to read. Okay, don't skip anything. So if the criminal proceeding is taken to a logical conclusion and the accused is found guilty, there will be imposition of sentence of fine or imprisonment of both, including capital punishment. Civil is normally you will be awarding compensation and damages. In a criminal proceeding, it will be typically imprisonment. Are you clear? Then I have taken some part of it because I deemed it important. Criminal courts and civil courts. The Gujarat High Court in Natwarla Jani and N.N. Jain, Chairman and MD of Prestige Foods, observed in that particular case, it was observed that policy or responsibility arising out of civil nature and a statute is one thing. It is another thing that very statute necessarily has to be treated under CRPC, read with relevant provisions, which makes that particular act an offence. Basically, you may say that one is a civil liability arising out of civil nature, but the penalty that it is stating is a criminal penalty. So you have to read it with that reference. So that particular act is an offence under Criminal Procedure Code, not under Civil Procedure Code. So if you take any liability, if the imprisonment is mandatory, it is a criminal offence. So you will have to follow the CRPC procedure. That is what they are saying. Understood? Any other point which is not clear? Last point. What it is the reference to that particular point. See, no civil, once it is an offence, obviously no civil court can exercise its jurisdiction. And the punishment has to be avoided by a competent court. Just because the statute creating an offence may not provide for a forum duly empowered to deal with penal provision. See, just because the statute is not specifically talking about it doesn't mean it's not a criminal procedure or a civil procedure. You have to see what kind of offence is created. Accordingly, you have to put it in the respective forum. Statute may not specifically mention it. That's all they are saying. I would suggest that you go through the original case. the whole case to get the clarity, more clear as to what exactly the case was. Then you can read it in context. Okay. There's something called public prosecutor and there's something called company prosecutor. Okay. Criminal cases are typically prosecuted by the state, representing the public and the society. So there is somebody called a public prosecutor who will ensure that they carry out the prosecution in such cases. A person who is eligible to be appointed as a public prosecutor or additional public prosecutor only if he has been in practice as an advocate for not less than 7 years. Central government and state government may appoint a person who has been in practice for not less than 10 years as special public prosecutor also. So 3 cases they are talking about who can be appointed. What are they there for? For prosecution in case of a criminal offence. Okay. So when a registrar or any other person who is entitled to file a complaint for offence under Companies Act, he files a complaint, the prosecution is conducted in the trial court by special category of officers called company prosecutor. So starting with, when registrar or any other person who is authorized files a complaint under Companies Act, it will go to a company prosecutor. Erstwhile, Section 624A of the Companies Act dealt with it. Okay. And they are appointed by central government. Company prosecutors have all the powers and privileges just like public prosecutors under Section 24 of CRPC. Clear? So, criminal courts and what are their powers is what we are going to be discussing. Courts of magistrate are basic courts for conducting trial of criminal offences. In metropolitan cities, Mumbai, Calcutta and Chennai, capitals of Maharashtra, West Bengal, Tamil Nadu, a special category of magistrates called presidency magistrates or chief metropolitan magistrates. This is a take from your presidency towns. They were original presidency towns and that is why they have presidency magistrates and chief metropolitan magistrates. Okay, High Court can award any sentence as authorized by substantive law. Then comes your sessions judge or additional sessions judge. They can award any sentence authorized by substantive law, but the sentence of death if they impose it is subject to confirmation by High Court. Come to assistant sessions judge. They can award imprisonment up to 10 years or fine. For fine, no upper limit has been prescribed. Then comes chief judicial, chief metropolitan magistrate. You can award imprisonment up to 7 years and or fine. Again for fine, no upper limit has been prescribed. And judicial magistrate of class 1 or metropolitan magistrate, subdivisional judicial magistrate, they can award imprisonment up to 3 years or fine up to 10,000 or both. So this is your hierarchy. Understand? The lowest in that hierarchy is judicial magistrate of first class, JMFC. Okay. Imprisonment only up to 3 years, fine up to 10,000 or both. That's your maximum. You can't go beyond that, and then the hierarchy they have given you. Are you clear? Okay. Now, Section 435 of the Companies Act deviates from the Criminal Procedure Code is what the analysis is. What is Section 435 of the Companies Act? Are you aware? Yes or no? No. Okay, give me a minute. I'll just put it in for you. It talks about jurisdiction of special courts. Okay. And it says, one second. Okay. What does it say? I'll just put it in for you. Then it will be easier, no, for you to handle. Put it in the chat box, yeah. And I'll keep this up so that you can actually compare what is going on. Are you clear? You are seeing the comparator. This is what Companies Act says. You can ignore this 430 which is there. That 430 is irrelevant. The section starts here, 435. Now compare this with what is stated here. This is as per the Criminal Procedure Code and this is what the All Companies Act tells you. You understand why we are saying it's deviating? Now, keep this in mind when we are reading the analysis. This is the analysis in your text. It says, Section 435 of the Companies Act states that offences that are punishable with imprisonment 2 years or more shall be tried by special courts. Other offences by special courts established or designated as Metropolitan Magistrate or Judicial Magistrate of first class. Correct? So, there is a deviation from what is specified by the CRPC. Just understand that there is a deviation and the two work slightly differently. Okay. Now what about courts under Companies Act? Therefore we must understand how that works. We have understood how the Criminal Procedure Code works. Now section 2 subsection 29(1) states that court means a high court having jurisdiction. In relation to the place, what we have already discussed, registered office of the company, except to the extent to which jurisdiction has been conferred to any district court or district court subordinate. States as the 229(2) states that court means district court wherever central government has empowered any district court to exercise all or any of the jurisdictions conferred upon the high court. So where it is not there, then it is high court. Otherwise, if the central government is empowered a particular district court to exercise all the powers of high court, then it will be the district court. That will be the jurisdiction. 229(3). Court means court of session having jurisdiction to try any offence under this act or under any previous law. 229(4) talks about court means a special court established under section 435, and 229(5) states that court means any metropolitan magistrate or judicial magistrate of first class having jurisdiction. So, under Companies Act, you have court of session, you have got a special court under section 435, you have court of metropolitan magistrate or judicial magistrate of first class having jurisdiction to try any offence under the Companies Act. Section 211 of the Companies Act 1956 described court differently. It is important in the context of offences under Companies Act 1956 that they had only two. With respect to any matter relating to a company, the court having jurisdiction under this act as provided under section 10, and they had said court of magistrate of first class or as the case may be presidency magistrate. Straightforward, simple, no further breakup. No reference is there to court of session. Only these two are there. Special court and court of metropolitan magistrate. Clear? Earlier. We are with this act now. Are you clear? Don't get confused. Okay. So, section 435 says, the central government may, for the purpose of providing speedy trial of offences by notification, that is what I have put up here, no, same thing, see. I just put it up so that at that context you needed it. Now, what does section 436 say? So again in Companies Act, it declares that notwithstanding anything contained in the Code of Criminal Procedure, all offences specified in section 435(1) shall be triable only by a special court established for the area in which the registered office of the company is situated, or where there are more than one special courts, then any of them as may be specified by the High Court. Where a person is accused of, or suspected of, or commission of an offence under this Act is forwarded to a magistrate under the CRPC, such magistrate may authorize the detention of such person in the custody as he thinks fit, for a period not exceeding 15 days. And 7 days where the magistrate is an executive magistrate. So suppose he is found to be a person who is accused of committing some offence which is forwarded to the magistrate under CRPC, then the CRPC magistrate, under CRPC, the magistrate can authorize detention of that person for 15 days if he is a judicial magistrate and 7 days if he is an executive magistrate. But this is under our Act, Companies Act. Are you clear? So if you want, I can give you the jurisdiction of special courts. If that you feel that will help you. If you want, I will give it to you. Okay, tell me. Okay. I'll have to put it in the chat box because I didn't think you might be interested. Sorry. But I'll put it in the chat box. That should be adequate, isn't it? What has come? Nilgiri, Salem. Okay, only till there it came. One second, no? Tirupur. Alright. Something more, I'm pasting it further. And then section 440 will apply in those places. Got it? That is just for your information. You can download it and go through. Section 436(2) of the Companies Act says, contains an important declaration that the special court, when trying an offence under this Act, may also try an offence other than an offence under this Act, with which the accused may, under CRPC, be charged at the same trial. So, special court is enabled to try an offence under CRPC also to that extent. It contains another non-obstant clause. What is non-obstant clause? Anybody knows? It means notwithstanding anything contained. Okay, that is, it says not withstanding anything contained, that's called a non-obstant clause. In CRPC, the special court may, if it thinks fit, try it in a summary way, any offence under Companies Act which is punishable with imprisonment for a term not exceeding 3 years. So in the Companies Act, the way it moves is slightly different. Very specific provisions have been given for the procedure, even though there is imprisonment. A proviso under this subsection clearly stipulates that in case of any conviction in summary trial, no sentence of imprisonment for a term exceeding 1 year shall be passed. So if it is a summary trial has been conducted, maximum, and if the person is convicted, then the person can be given a punishment of only imprisonment of 1 year, not beyond. If they feel that the punishment should be more than 1 year imprisonment, then they should record that order and hear or rehear the case and treat it as non-summary trial. Am I clear? Now, Section 437 of the Companies Act is this, they have actually given the sections. I am not giving it again. Okay. The High Court may exercise all the powers conferred by the specific chapters of the CRPC on High Court. Once again, Varsha, I'll just complete this and go back. As if a special court within the local limits of jurisdiction of High Court, where a court of session trying cases within the local limits of jurisdiction of the High Court. Basically, High Court can exercise all the powers specified by CRPC, which is given by CRPC on a High Court. As if the special court, which is within the jurisdiction of that High Court, were a court of session within the local limits of jurisdiction of the High Court under CRPC. Special court is under Companies Act, court of session is under CRPC. In other words, if a matter goes up to High Court, within whose jurisdiction the seat of that special court lies, special court will be treated like the court of session under CRPC. Clear? Okay. So what I said here is, see, when you are doing a summary trial, no, there are some rules. So under summary trial, what it says is, you can take up the summary trial only if the term of imprisonment which is probably allowed in that particular case is not beyond 3 years. That is what we said here in this place, correct? Then it says, no sentence of imprisonment for a term exceeding 1 year can be passed. If it is summary trial, the maximum term of imprisonment that can be passed is 1 year. If the special court feels that imprisonment period should be more than 1 year based on the kind of offence, then they will have to order for retrial and not treat it as a summary trial. Are you clear? Anything here which is not clear? Okay. Now, next point will be on summons. It's about summons. Okay. So for that, I have to pick up from your criminal procedure code. Just give me a minute. I'll put it in the chat box for today. Next time I'll repeat it and take you through it again. I just want to show you how it looks. I'm just dragging it in, just give me a minute. What is a summons case, first of all? It means, see how they have defined it in criminal procedure code. I put that in first. Yes. Maximum imprisonment and the summons under your summary trial is 1 year. So maximum that they can try is for a imprisonment of 3 years. The 3 years thing will be reduced to 1 year. So then you need to know what is a warrant case, right? So we look at what is warrant case. See this. Have clarity on whatever I am telling you now. Are you clear, Neha? Okay. Read what's a summon case, what's a warrant case, have a look. This is all defined in CRPC. So now why I am telling you all this? What's the next thing, no? See, next procedure which we are going to be dealing with is trial procedure for summons case. What is a summons case? What is a summons? Summons means a person is going to be called, summoned. Okay. A summon is an authoritative call to the accused person to appear in the court to answer to a charge of an offence. Okay. Now, summons case is what and warrant case is what that I have given you. What is a summon? I'll just put up for a minute. Okay. One second. Huh? I just want to leave you at that point so that you will think about it and then we can continue from there. Summons case means a summons is issued to a person to appear, right? While a warrant case is where a warrant is issued, which is an arrest warrant. Are you clear? We'll see it in detail.